Well, Unit 4 was all about the government institutions. Well, Unit 5 is going to be more about you, your rights, and your responsibilities. And it's going to focus on First Amendment freedoms, rights of the accused, and the civil rights movement. Starting with the Bill of Rights. The Bill of Rights protects people's individual civil liberties. I'm going to use BOR as an abbreviation for the Bill of Rights. Civil liberties, by definition, are the people's rights protected by the Constitution against government interference. So you have rights like freedom of speech, freedom to assemble, freedom to petition the government without the government interfering with you or taking those rights away. The most fundamental or important of these civil liberties are the civil liberties that are protected by the First Amendment. And it is the government's job, particularly the court system, for balancing individual civil liberties with the interest of society. Many Supreme Court decisions set boundaries and guidelines of how the government may limit civil liberties but protect the public good. So you can practice your freedom of speech, you can practice your freedom to assemble, you can protest, you can picket, as long as you don't hurt anybody else. If you're hurting somebody else, that's when the government is going to start to get involved. So again, you can protest, march, and also you can completely worship your own religion as long as it doesn't hurt anyone else. Freedom of the religion is the first mention of a right or civil liberty in the Bill of Rights and in the First Amendment. So behind here, you see the slide says the First Amendment. Congress shall make no law respecting an establishment of a religion or prohibit the free exercise of. So we're going to start with religion. Freedom of religion is protected by two clauses or statements in the First Amendment. I just read them to you. The first clause is the Establishment Clause, which is derived or comes from Thomas Jefferson. Thomas Jefferson wrote the Virginia Statute of Religious Freedom. In that Statute of Religious Freedom, Jefferson talks about a wall of separation between church and state, which means the government is the state, and a church, of course, is religion, and the government and religion should not mix. Government shouldn't get involved with it. We can't have an official religion or favor one religion over another in this country. So you have just as much right to be a Christian as you do an atheist, as you do a Muslim, as you do a Jew, as you do a Hindu. All of them are acceptable. Now that's important because if you look at our United States, the red are Southern Baptist, the green, I believe, are Lutherans, the blue is Catholic. Okay, so we have all sorts of different religions in this country. The brown are Mormons. You can't say that Mormons can't practice their religion or Southern Baptists can't practice their religion. Everybody is able in this country to practice their religion as long as they don't hurt anyone else while doing it. Okay. Limits on government supporting religion. Okay, I'll go over these court cases in a moment. A lot of controversy exists around government saying what religion can and cannot do. It is up to the Supreme Court to define the Establishment Clause and what is and is not allowed when it comes to government getting involved with religion. The most controversial cases dealing with religion and public institutions that are run by the government deal with religion in schools. The Supreme Court has had to make some decisions that are important in defining the role of religion in schools. Two Supreme Court cases that you need to know regarding religion in schools are Engel versus Vitale. In Engel versus Vitale in 1964, the Supreme Court looked at the controversial issue of teachers leading students in prayer. And the Supreme Court decided that if a teacher who is paid by the government leads a child in prayer, that is a violation of the separation of church and state or the Establishment Clause. So no teacher may lead prayer in schools. I cannot pray to you. Lemon versus Kurtzman was argued in the 1970s. Lemon versus Kurtzman deals with federal government giving money, federal and state government giving money to private religious schools. Now that money comes from our taxes. That money people argued that money should go to public schools, not private religious schools. So the Supreme Court had to answer, can the government give a religious school money? And the Supreme Court decided the government can give a religious school money as long as they don't spend that money on anything that's going to further the religion or support the religion. So the government can give money to a religious school if they're going to spend it on math books, but they can't give it to a religious school, if they're going to spend it on Bibles. Okay. Here's one fake street sign that kind of puts into perspective government or our opinion of church and state, that they should go their separate ways. But here's what George Washington said about religion. He said it's impossible to rightly govern a nation without God and the Bible. So even some of our founding fathers were religious men. Now, the Establishment Clause has also included tax laws. In one other Supreme Court case questioning the Establishment Clause, we question whether or not the government can give a sales tax exemption to churches. So if a church goes to Walmart and buys a bunch of sodas for a youth group, do they have to pay sales tax on those sodas? And the Supreme Court said, no, they don't. The government gives a tax-exempt status to any church as long as that church doesn't discriminate against one particular group of people. Like if it's an all-white church that doesn't allow any black members, then they're not going to get a tax exemption. So you have to allow for anybody and everybody to come join your church. And then you don't have to pay sales tax or property tax or anything of the sort. It is okay for the government to do a couple of things. And you're probably thinking to yourself, why do we put "In God We Trust" on our government money if we have separation of church and state? And why do we put "Under God" in our Pledge of Allegiance if there's separation of church and state? Well, these references to God on money and in the pledge are references that are custom and tradition. And the reason we accept this on our money and in our pledge is because they reflect the beliefs of many U.S. citizens. 90% of America, if not more, I think it's about 92 to be honest with you, 92% of Americans are Christians. So 92% of Americans don't have a problem with "In God We Trust" on money and don't have a problem with "Under God" in the pledge. The second clause that references religion in the First Amendment is the Free Exercise Clause. So the Establishment Clause is that the government can't establish a religion, and the Free Exercise Clause says that you are free to practice any religion you choose. Like this woman right here is practicing some voodoo. She's about to sacrifice that chicken. And that is totally okay in America. As long as you didn't steal the chicken, you're okay. So, the only time we restrict free exercise clause is if the practice includes some criminal activity. So, you can't sacrifice human beings and tell the government, it's okay, I was just practicing my religion. No, that's not cool. Like I said, you can practice voodoo, you just can't steal the chicken if you're going to sacrifice it. So, you can't do anything illegal in the process of practicing your religion. The following cases are important in defining free practice. Reynolds versus the U.S. The Supreme Court said that Mormons cannot practice polygamy. And polygamy means you have more than one wife. So Mormons cannot legally have, and that's the fundamentalist Latter-day Saints. Not all Mormons believe in plural marriages. But you cannot practice polygamy as part of the protection of your religion. And the argument was is that some of the people that were put into these marriages, these multi-wife marriages, didn't choose that situation. Okay, the other one is Wisconsin versus Yoder. Wisconsin versus Yoder is a Supreme Court case regarding Amish kids. And Amish kids were dropping out of school at 8th grade to go work on their farms. That was what the Amish did. That was custom and tradition in their religion. They dropped out of school and they go help their parents on the farm. But we had laws, and we still have laws that say you have to stay in school. So the Amish were like, but staying in school is counteractive to our practicing our religion. And the Supreme Court said, fine, you could drop out of school in 8th grade if you're Amish. And there you go. There's your two clauses that deal with religion, Establishment Clause and Free Exercise Clause. With the key to Free Exercise Clause is you can do what you want to practice your religion. You just can't hurt anybody. And the government, with the Establishment Clause, the government can be slightly involved with religion, but they can't advance or promote any one particular religion.